JBNN will keep you informed. I'm Michelle Jones. Before we get into the news, please remember to like, subscribe, leave a comment, and share the news with family and friends today. Now on to the news. Residents of Bunkers Hill, Trelawney, hand over guns found in debris to police. 2 guns and 3 rounds of ammunition were found in debris by residents of Bunkers Hill in Wakefield, Trelawney on Thursday and handed over to the police. The weapons were a .45 pistol and a .38 pistol, along with 3.38 rounds of ammunition. The police report that at about 10:30 a.m., residents saw the guns and ammunition among debris and took them to the station. No one is arrested in relation to the seizure. Investigation continues. Selector gunned down after leaving nightclub. A sound system selector was gunned down this morning after leaving a nightclub in St. Andrew. He has been identified as 33-year-old Gavin Woolcock, otherwise called the Mafia, of a St. Andrew address. He is reportedly linked to popular sound system X Factor Sound. The police report that Woolcock had concluded selecting duties at the 420 nightclub and left the venue with his girlfriend in his car. It is reported that while at a stoplight on Constant Spring Road, in the vicinity of the entrance to the Manor Center Plaza, it was pounced upon by unknown assailants who opened gunfire, hitting him in the neck and upper body. He was assisted to hospital by the police, where he was pronounced dead. The police say 3 spent shell casings were removed from the scene. No motive has been established for the murder. Former Indicom boss awarded $50 million in defamation lawsuit against Police Federation and ex-chairman. Former head of the Independent Commission of Investigations, Indicom, Terrence Williams, has been awarded $50 million in damages in a defamation lawsuit he filed against the Jamaica Police Federation and his former chairman, Patrick Rowe. The oral judgment was handed down in the Supreme Court on Friday. Attorney Sir Williams confirmed. Williams acknowledged that he is aware of the judgment but declined to make any comment. The lawsuit stemmed from a statement the police union released to the media in May 2020 containing scathing criticisms of the former Indicom head. Williams was represented by Titania Small Casey and Catherine Williams, instructed by the law firm Livingston, Alexander and Levy. Driver who mowed down firefighter in St. Ann fined $600,000. Ortliff Thomas, the driver who pleaded guilty to mowing down firefighter Lawrence Dowes in Otrius, St. Ann, has been fined $600,000 or 12 months imprisonment. Sentencing was handed down in the St. Ann Circuit Court. Thomas was charged with vehicular manslaughter following the incident in 2022. He, however, pleaded guilty to causing death by dangerous driving. Facts are that at about 2:40 p.m. on November 30, 2022, members of the St. Ann Fire Brigade were responding to a fire near the Reynolds Cruise Shipping Pier along the Otrius Main Road. Thomas overtook a line of traffic and lost control of the vehicle, which slammed into the fire truck, pinning Dowes to the truck's body. The car then burst into flames. Frantic attempts were made to remove the pinned Dowes. Dowes was eventually cut from the wreckage and rushed to the St. Ann's Bay Regional Hospital, where he died. Thomas was hospitalized from injuries received in the collision. He was subsequently arrested and later charged. Carousel execs look to recover monumental losses. Symbiote Investments executive Minette Lawrence has expressed confidence that there will be full restitution and compensation for the monumental losses suffered due to their failed criminal prosecution. The Court of Appeal last week struck out the notice of appeal, which was signed by the Director of Public Prosecutions, seeking to overturn a lower court's decision to free 4 executives of Symbiote Investments Limited, a tech firm, of criminal charges. Lowell Lawrence, Chief Executive Officer and Director of Symbiote, with trades as Carousel, his wife Minette, who is the company secretary, Natalie Neal, company director, and Livingston Hines, principal shareholder and the director of Extranet, were freed in the Kingston and St. Andrew Parish Court last June. They were accused under the Telecommunications Act of broadcasting without a spectrum license. The DPP filed the notice of appeal in the Parish Court on July 13 last year. The 4 filed their application in the Court of Appeal last September for the notice to be thrown out. On July 11, Attorney at Law Dr. Mario Anderson, who represented the company officials, argued that the appeal should be struck out because it had no foundation in law or practice and was a continuation of the reprehensible abuse of judicial process which had characterized the proceedings before the Parish Court. The lawyer argued that the prosecution failed to disclose evidence that the Carousel spectrum license had been revoked or that the defendants had knowledge of such revocation. He also said the prosecution repeatedly failed to satisfy the parish court judge's request for proof that proper disclosure had been made. Assistant Director of Public Prosecutions, Jodian Edwards, and Crown Counsel, Kemar Sital, and Sarah Hope Cochrane Spencer represented the DPP. The appeal court, comprising Justices Paulette Williams, Carol Edwards, and Acting Judge of Appeal Kizok Leng, agreed with Dr. Anderson's arguments and struck out the prosecutor's notice of appeal. Commenting on the outcome, the Lawrences said that their victory was a triumph of faith because the entire experience with Carousel was orchestrated to destroy their business as well as their reputation. When the might and power of the government is brought against ordinary citizens, only God can help you. So we turn to God, and we're grateful that He answered, they added. The executives were charged in February 2020 with 1 count of conspiracy to use the spectrum without a license and 5 counts of use of spectrum without a license. In their defense, they objected to the charges and described them as an abuse of the process and argued that they were not arrestable offenses. They also argued that the prosecution failed to produce witnesses or evidence to support its case. It was further submitted that the police, having forcibly shut down Carousel's operations and seized its equipment, wanted to justify their conduct and retain custody of the equipment valued at over $9 million. The parish judge upheld the submissions, dismissed the case, and ordered the immediate return of all the equipment seized. However, to date, the equipment cannot be accounted for, and the demise of the appeal means there is no further impediment to the parties pursuing their claims for compensation for false imprisonment, malicious prosecution, and damages for the detention and or value of the equipment, the Lawrences disclosed. Carousel's business was transferred to local licensed operator Extranet. I am confident that there will be full restitution and compensation for the monumental losses which we and our families suffered, Minute Lawrence said. My one regret is that the cost will be borne by the taxpayers who lost the opportunity to have the benefit of a world-class internet service, and now they'll have to cover the cost. I look forward to the time when public officials will be held personally accountable for their misconduct and abuse of power. Supreme Court rules on signed police witness statements inadmissible. The Supreme Court has ruled that witness statements recorded by police investigators but not signed by them are inadmissible in court. The ruling provides a partial legal victory for Trelawney Mann, who was ordered to stand trial for murder. The decision by the Jamaican High Court, however, affirmed the long-standing practice by cops to record their own witness statements in the presence of a colleague, providing he is not below the rank of sergeant. The ruling was handed down last Wednesday at the end of an application filed by Kenya Robinson for leave to seek judicial review of the decision by a judge in the St. James Parish Court to transfer his murder case to the Circuit Court for trial. The application was granted, but limited to the statutory requirements contained in Section 6 of the Committal Proceedings Act, CPA, Supreme Court Judge Justice Sonia Wint-Blair ordered in her decision. Section 6, subsection 2 of the CPA stipulates that a witness statement, written or electronically recorded, is admissible as evidence similar to oral evidence in a committal proceedings hearing if it is recorded by a member of the police force in the presence of either a justice of the peace or another police officer not below the rank of sergeant. A witness statement is also admissible if it purports to be signed by the person giving it and the person recording it, subsection 2b stipulates. Further, subsection 3a mandates that the statement shall state whether it was made by a person who has attained the age of 18 years old and shall state the age of the person if it is made by someone under that age. Robinson, a 35-year-old swimming instructor, was charged by the police in St. James for the stabbing death of a security guard during an altercation at a club in the parish on October 3, 2022. In November 2022, during a committal proceedings hearing in the St. James Parish Court, its attorneys objected to the inclusion of the statements given by 2 police witnesses and a civilian witness, arguing that they were not compliant with Section 6 of the CPA. The issues the attorneys argued then were that the police had recorded and signed their own statements, and that the statement of the civilian witness was not signed by the cop who recorded it and did not include her age. The witness statements of the 2 cops were signed by a sergeant and an inspector. At the end of the hearing, Parish Judge Sasha Ashley ruled that the statements were admissible and that prosecutors had established a prima facie case against Robinson. The case was set for trial in the St. James Circuit Court. But while awaiting his trial, Robinson, through his attorneys John Jacobs and Lemmer Neal, of the law firms Jacob Law and Nealex, respectively, sought leave to challenge Ashley's decision before the Judicial Review Court. They also sought an order of certiorari to quash the decision of the parish judge and a declaration that a prima facie case has not been established against their client. Neal argued in his submissions before the Supreme Court that by admitting the impugned statements of the two cops and the civilian witness, Ashley acted outside the scope of Section 6 of the CPA, rendering her decision to commit Robinson to stand trial for murder ultra virus. However, in opposing the application, Stuart Stimson, the government attorney who represented Ashley, argued that there is a requirement in the legislation for the person giving the statement and the person recording it to be two separate persons. Stimson acknowledged that the statements of the two cops did not indicate their age, but said Ashley, at her discretion, could have taken judicial notice of the fact that members of the police force must be at least 18 years old. He insisted that the parish judge properly concluded that all three witness statements satisfy the requirements of Section 6 of the CPA. Justice Wintblair, in her judgment, said that the statement of the civilian witness complied with Section 6.2a of the CPA, but said it was in breach of subsection 2b because it was not signed by the cop who recorded it. The statement is signed by the maker, however, the recorder has not signed it, which is a breach of Section 6.2b of the CPA, Wintblair declared. She noted, too, that the statement did not indicate that the civilian had attained the age of 14 years, but pointed out that the redacted age of the witness is stated on the first page of the statement. But for the failure of the recorder to sign it, the statement is otherwise compliant. Wintblair also agreed with Stimson's submissions that there is nothing in the CPA that requires the person giving a statement and the person recording it to be two separate persons. I fail to see why not. The natural and ordinary meaning of the words used in this section cannot be given a meaning that linguistically they cannot bear unless the context lends itself to that interpretation. Nothing in Section 6 requires giving the words person or maker an exclusionary meaning, she said in her judgment. JBNN, we keep you informed. Please remember to subscribe, like, share, leave us a comment, and click the notification bell to receive our daily news items.